even if they believed that Chiquita was under threat and was facing security challenges in Colombia, paying the paramilitaries to commit brutal acts of violence did not reduce the conflict in Colombia. It did not turn down the temperature.
Hi there, and welcome to Voices from the Institute for Human Rights in Business, also known as IHRB. I am Deborah Sago, and in this podcast, you will hear from people working to make respect for human rights part of everyday business. You've just heard from Marco Simons from Earth Rights, an NGO that takes legal action against institutions that violate human rights and cause environmental abuse. Marco is talking about a recent ruling in Florida that has found the company Chiquita liable for killings committed by a paramilitary group that was on the company's payroll. You'll hear more about that in a moment, but first, let's hear from my colleague Salil Tripathi. Salil, can you tell us a little bit more about Chiquita? There is a broader context to this case that's important, isn't there?
Yes, Chiquita is one of the leading brands for bananas in the world. And the phrase banana republic and Latin America often go hand in hand. If you look at the history, Chiquita's forerunner was a company called the United Fruit Company. And for those of us who are interested in literature and have long memories, would have vivid memories of the novel 100 Years of Solitude by Gabriel Garcia Marquez, which won the Nobel Prize in the 1980s. In that novel, he talks about the United Fruit Company massacre, which took place in 1928 in the village called Ciénaga, where workers were trying to organize into a trade union. And he talks about bodies being tossed in the river. He talks about bodies being packed into boxes as if they were stale bananas and being shipped away. And it's a very graphic image of the violence that took place. Then, of course, we know Pablo Neruda, the great poet, who also won the Nobel Prize, who also wrote a poem which was called United Fruit Company in 1950, where he talks about the trumpet sounding and everything is prepared on the earth. And at that time, companies from the West come and companies from the US come. I suppose the point of recalling these poems is essentially to remind ourselves that banana has a very resonant feeling in the countryside in Colombia and other parts of Central America. And what happened in the 1980s and 90s is when Colombia had this civil war that was raging, there was a left-wing group called FARC and a right-wing group called AUC. And those two groups were vying for supremacy, and they would often get control of land area around plantations such as Chiquitas and then seek protection money, and the companies would pay up because they wanted their goods to go, and that created a relationship and which exposed them to the risk of complicity. So that's a very long way of explaining how bananas have a great resonance and how they're intimately linked with the human rights abuses and the politics of Colombia and of Latin America.
Thank you, Salil. The use of private military contractors, or PMCs, and private security companies, also known as PSCs, is important to this case. Later on, you will hear about some of the challenges faced by companies who contract non-state actors such as these, or end up being protected by militia groups or even rebel forces. You'll also hear about the guidance around this, which can help mitigate potential human rights risks. But first, let's hear from Marco, who gives Salil an outline of the case.
So Chiquita operated in Colombia for a very long time. They were originally known as the United Fruit Company, which has a long and, you might say, checkered history in Latin America. And around 1990, Chiquita engaged in an expansion project in Colombia, which was challenging because Colombia was in the midst of an armed conflict at that point. And immediately after, when they started expanding, they started receiving extortion demands from left-wing guerrilla groups who at various points attacked Chiquita facilities, burned Chiquita packing stations, and sent various extortion demands. So in the mid-1990s, Chiquita started essentially employing paramilitaries as security to protect their farms in Colombia and their operations there. And by 1997, they were paying an enormous amount of money to a paramilitary organization known as the United Self-Defense Forces of Colombia, or known as the AUC for its Spanish acronym, which was widely known and known to Chiquita for horrendous human rights abuses throughout Colombia, but especially in the banana growing regions where Chiquita operated. And for a period of at least 7 years, Chiquita continued to pay these murderous paramilitaries as they killed thousands of people in Colombia, including essentially anyone who was suspected of being a leftist, not limited to guerrillas or guerrilla supporters or sympathizers, but anybody who was suspected of being a leftist, anybody who was seen as opposed to the paramilitaries, folks who were seen as sort of socially undesirable. It was essentially a combination anti-guerrilla and social cleansing operation with numerous massacres, horrific ways of killing people, torture, the theft of an enormous amount of land from ordinary farmers as well. And Chiquita admitted both that it made these payments to the AUC and that it knew this whole time that the AUC was a horribly violent, brutal organization that was engaged in this campaign of violence against civilians. But they essentially justified their ongoing support of the paramilitaries because they believed they needed the security support and because there appeared to be an ideological alignment between Chiquita and the business community and these paramilitaries.
And the state security was absent, am I right? I mean, the state security was playing no role in protecting Chiquita, and that's why they had to go to these right-wing paramilitary forces, am I right?
I wouldn't say they were playing no role, but it was definitely the case that many people throughout Colombia felt that the governmental security forces, police and military, were unable to fully sort of control the situation, especially in the countryside. Now, that's not to say Chiquita didn't have other options, of course. And Chiquita easily could have withdrawn from Colombia and reduced its footprint. The one remarkable thing I think that we established during the trial was that not only did Chiquita continue its operations, but it continued expanding its operations through this period. Chiquita continued to increase its footprint, to buy additional farms in Colombia up until at least 2002. So throughout the worst of this period. So they weren't making any efforts to reduce their exposure here. They were essentially doubling down and profiting off of the conflict.
So, Marco, you mentioned the trial. So let's talk about the case. What were the legal issues involved? Who were the litigants? And how did that happen?
Yeah, so together with other lawyers, we represent a number of victims of this paramilitary violence. And in fact, thousands of victims have filed suit against Chiquita in the United States, where Chiquita is headquartered and incorporated. And this trial was not a comprehensive trial of all these thousands of cases. It was a handful of plaintiffs, victims' families who were picked as kind of representatives, but known as a bellwether trial, essentially a trial to help determine the direction of the broader case. And so different lawyers representing different clients came together in sort of a unified front to present their case, led by a very accomplished Florida trial attorney, Jack Scarola. And ultimately, we presented the cases of 9 deaths to a jury in Florida. And these were all people who had been murdered by the paramilitaries during the period when Chiquita was supporting the paramilitaries. And the jury found in 8 out of the 9 cases that Chiquita bears responsibility for their deaths and awarded over $2 million in damages to each family member who brought claims in the court in Florida. Additionally, the jury specifically rejected defenses that Chiquita had raised that they were essentially that they had no choice but to pay these paramilitaries. That was Chiquita's main argument during the trial, was that they were also a victim of the paramilitaries. They argued that they were legally excused from liability because of the doctrine of duress, essentially that they were being forced to make these payments, that they didn't have a choice in the matter. And the jury specifically rejected this and found that Chiquita did not meet the requirements for a duress defense, And so they rejected Chiquita's whole framing of the case here. And I think the jury, in the jury system, we don't get a lot of information about exactly what they were thinking. But even if they believed that Chiquita was under threat and was facing security challenges in Colombia, paying the paramilitaries to commit brutal acts of violence did not reduce the conflict in Colombia. It did not turn down the temperature. At best, it ensured that Chiquita was protected while shifting the target of that violence to other people, including the plaintiffs who brought suit in this case.
Yeah, and it continued the misery. It continued the pain and the misery. I know complicit is a very loaded term, but it does make the company complicit in this issue.
Absolutely. And that's what the jury found.
So my question is this. I mean, this is a civil case, but it is not an Alien Tort Statute case. Am I right?
That's correct.
Yeah. So tell me what law is involved in this case.
Yeah, I'm glad you raised that because we did originally file this case in part under the Alien Tort Statute, which is a U.S. federal law that allows lawsuits in federal courts for violations of international law. But the scope of that statute has been limited by the decisions by the U.S. Supreme Court during the course of this case. This case was filed 17 years ago. And so it is now much more difficult to bring cases where the injuries occur outside the United States. But as human rights litigators in the United States, we have never really needed the Alien Tort Statute to bring cases for human rights abuses outside the United States.
Where the defendant is American, am I right?
Where the defendant is a U.S. company or otherwise subject to jurisdiction in the United States.
Right.
Because that's not the principle that you can sue a U.S. company for abuses, for violations of the law that they have committed outside the United States. That is a long-standing legal principle that's hundreds of years old and that doesn't depend on the Alien Tort Statute. The unique thing about the Alien Tort Statute is that it brings concepts of international law into these proceedings. So under the Alien Tort Statute, we could have brought claims for things like crimes against humanity and torture and war crimes. And that's important because that's, putting the correct labels on the wrongs that have been committed here. But that's not the only way to characterize these claims. And so under ordinary domestic legal principles, you can bring claims for negligence and wrongful death. And so that's essentially how these claims were characterized. And the court in this case decided that the claims would proceed under Colombian substantive law, so under Colombian principles of tort liability, and so simply applied Colombian law. And that is not that unusual in U.S. courts for cases that have some sort of international or transnational aspect to it. U.S. courts fairly routinely find themselves needing to apply the law of another country. And so that's not a barrier to bringing a lawsuit in the United States. So I guess one message that I would want to send is that for anyone who thinks that the limitations on the Alien Tort Statute have limited our ability to hold U.S. corporations accountable for human rights abuses around the world, I hope this is a wake-up call to send that message that no, U.S. companies still need to be, very careful and respectful of human rights around the world because we don't need the Alien Tort Statute, which is an extremely important law that has extremely valuable purposes, but we don't need it to hold corporations accountable for such clear violations of the law.
Now you mentioned 17 years, and that was my next question. It's a long time, right? I mean, for the victims, for the survivors, for everybody, people's memories fade and so on. People want to move on. The company hopes to keep pushing the ball further into the grass so that it keeps getting ignored. So how does that get played out? I mean, it's very nice to know that this case can be heard and this case can be tried and that we don't need ATS despite what happened in the Kiobel case about Shell and Nigeria. But we still have an enormous amount of time period involved. So is that a given?
I hope not. And in fact, we've brought other cases to resolution in shorter time periods, but this also isn't the longest one. So these cases often do take a long time. And that's due to a combination of factors. Here, this was a very large and complex case with thousands of victims. But Chiquita also threw up every legal obstacle they could think of to prevent this case from going to trial. We've had 2 trips to the Court of Appeals before getting to this trial. So I think you're absolutely right that our ability to deliver justice and accountability is lessened if it takes so long. But it's not eliminated entirely. And I think even if it takes 17 years, 20 years to get remedies, what we're hoping is that companies in similar situations are looking at this litigation and saying, we don't want to be in that situation, right? We don't want to endure decades of litigation. We don't want to risk tens of millions or even greater judgments for liability. We don't want to be seen as essentially a corporate pariah for our behavior. And so some of the results that motivated the plaintiffs in bringing this suit are achieved even before we get to a jury verdict. But there's no question that I would love to see these cases moving faster. It is a sort of downside to litigation as a method of bringing accountability, but we usually only resort to litigation when we're out of other options.
Right. Because the reason I ask is also this is a year where we are going to observe, celebrate is not the word, honor is not the word, it's observe the 40th anniversary of Bhopal, which still has aspects of that case remain pending. There was a major gas disaster. 2,000 to 3,000 people died immediately. At least 20,000 people have died over the years. There's a problem with water contamination and all that. So do you think the Chiquita case give us hope that such cases can get resolved faster? And more particularly of the Chiquita case itself, what is your prognosis? What is the next step? I'm sure the company would want to appeal.
So, the Bhopal tragedy is, I think, does represent a failure of the justice system, both in the United States and in India. And I've had some involvement in legal efforts to try to hold Union Carbide accountable for the ongoing water pollution that remains in the Bhopal community. That was also, as I'm sure you know, a political failure to some degree because the Indian government decided to essentially eliminate Union Carbide's liability through the Bhopal Act and legislatively determine the outcome there, which had a huge impact on the ability to hold the company accountable in court. So there are certainly bright spots and dark spots in this whole corporate accountability journey. But I know that advocates are continuing to fight on Bhopal and continuing to work on the issue. And, we've talked with lawyers and campaigners in India multiple times over the years to continue exploring those options. So I would not say the door is closed on accountability especially for the ongoing water pollution in Bhopal. In terms of Chiquita, the next steps, as I said, there are thousands of victims here, and this trial resolved the claims of 9 of the victims. And so it only represents the beginning of Chiquita's potential liability, right? So as you might guess, this trial took about 6 weeks with about 60 witnesses and thousands of pages of evidence to hear the claims of 9 plaintiffs. It's essentially a practical impossibility to do that for all of the victims in this larger case. So a resolution at some point would probably have to come through either a settlement or if Chiquita is driven into bankruptcy. And so ultimately, we're not looking to drive Chiquita into bankruptcy. We are hoping to, at some point, come to an agreement that would fairly compensate all of the victims here, rather than being in trial for the rest of our natural lives. But the immediate next steps, Chiquita has said they will appeal this verdict. And one issue that they are especially concerned about right now is that they are claiming that although the jury awarded each plaintiff more than $2 million in damages, that they claim those damage awards should be reduced to approximately $50,000 each based on their interpretation of Colombian law that they claim limits damages in these cases. Now, we strongly disagree with that. And we think it would be a further, I think, essentially violation of fundamental human rights to accept Chiquita's argument, because all along, all throughout Chiquita's conduct in Colombia, I think one of the reasons that they went along with fueling conflict in Colombia was that they essentially did not value the lives of the people in the communities where they were operating. And this would continue that trend if Chiquita's motion were granted in this respect. But I think that is one issue they are likely to want to fight out on appeal, because obviously the difference between the value of a claim to Chiquita and the threat of a claim, if it's worth $2 million versus $50,000, makes a huge difference to them in terms of their overall liability here. So we hope the courts won't follow Chiquita down this path of devaluing the lives of Colombians, but that is an issue that they are going to fight on.
So one final overarching question I have is that you probably know that there has been talk for some time of a binding treaty for companies for their conduct at home or abroad. Obviously, this is wonderful to hear what you're saying about what's happening with Chiquita. On one hand, we have the Lundin trial going on in Europe, and we have the Lafarge-Holcim case going on in France, which are all similar type of instances where companies are being held to account for fairly grave abuses. Is it time to rethink about how such a treaty can be formulated so that we have greater accountability? So that, of course, it's wonderful to have the UN guiding principles and the due diligence processes and heightened due diligence when you operate in zones of conflict, but that's still placing the onus on the company. The role of the state as a regulator, as an enforcer, is often missing. So do you think it's time to do that, and what are the elements you would like to see?
Boy, that's a big question. But look, I've sort of jumped in and out of the treaty advocacy over the years, and I wouldn't claim to have a comprehensive view of what such a treaty should cover. But from my perspective as a litigator, I think there are a couple of things that are worth thinking about. One is, in these efforts to hold corporations accountable, are there coordination problems between countries that a treaty can help solve? And that, in terms of, for example, agreements regarding how judgments can be enforced across countries, in these sorts of cases, how discovery processes and evidence gathering processes across countries. There are already treaties on those to some extent, but they have their limitations. So that might be one thing to look at. What are the barriers to accountability here? And the other area I would look at is the big obstacle to achieving a treaty at this point has been that the major capital exporting countries have just not been willing to go along with any strong mechanisms, right? And I have sometimes thought, well, do you need to be sort of held hostage to the richest countries in the world? What if we looked at a treaty from the lens of, well, what would be useful if only developing world countries signed on to this, right? What could still be useful in protecting communities and holding corporations accountable, even if you just ignore the home countries of the major multinationals, the US and China and the EU, for example, right? Even if those were never part of such a treaty, what advances could you make in terms of domestic accountability procedures in the developing world, in the poorer countries? And look at it from that perspective, because countries rarely sign treaties in order to put themselves or their own citizens at a disadvantage. I'm not at all suggesting that the project of holding the U.S. government, pressuring the U.S. government and the EU and China to sign on to such a treaty should be abandoned. But I also wonder, well, what if we looked at if, for example, in this case, if the Colombian government were to sign on to a treaty, what would have been helpful in a case like this, even if the U.S. is nowhere to be seen?
Yeah, that's very useful. I know there's a lot of work ahead for you, and you've been in this struggle for a long time, so more power to you and more support to you, and all the very best. Thank you so much.
Thank you so much, Salil.
Some very interesting points there raised by Marco. Salil, what is your take on the importance of this case?
I think the significance of this case is that companies need to be aware of what happens in their name or on their dime wherever in the world. So if they're operating in one country, they cannot simply wash their hands off saying that we did not have any control. If they have a contractual relationship, then they're required to ensure that the contracting party, which is going to execute their work, acts as per international standards. They would do that for food safety. They would do that for workers' rights. So why can't they do the same for protection of communities? And if you don't do that, as the Chiquita case shows, and there are a few other cases also that are coming up now dealing with Lundin in Sudan and Lafarge, the risk of complicity increases, litigation risk increases. Sometimes it could be a civil case where they have to settle the matter by paying a huge fine. And sometimes it can be a criminal matter where there can be a prosecution, conviction, and even a prison term.
And companies do tend to use PMCs and PSCs, don't they, Salil?
Yes, Gabra, you're right. I mean, companies do indeed use private military companies and private security companies. And as we have seen in this case involving Chiquita, paramilitary groups are also sometimes used. And that takes us into a very shaky and dangerous area because you're talking with non-state actors who might not be legitimate actors. But PMCs and PSC, my understanding is that they're legitimate actors. And who else but our colleague, Vicky? I would like to bring her into the conversation. Vicky Bowman founded and ran the Myanmar Center for Responsible Business, but she also has many other hats. And one of them is that she's on the board of ICOCA, which is this organization that regulates and administers a code of conduct for companies which provide security to corporations. So I just thought, Vicky, it would be a good idea for us to talk a little bit about it. And, just for people who don't know the difference between a private military company and a private security company, what is the difference, if any?
So it's a difficult question to answer because there isn't a fixed definition of either. And also there's a spectrum of different sorts of organizations. And on top of that, people tend to pile them together as PMSCs, private military and security companies. But basically, when you're talking about private military companies, and sometimes people call them mercenaries as well, and potentially those could be paramilitary organizations as well, then they tend to be companies who are pursuing their goals through force and often aggression. So they're not fundamentally defensive. Whereas if you're talking about private security companies, PSCs, you're talking about companies who've been hired by another company to defend their people or their property. So their stance is entirely defensive. They're not pursuing military approaches. And I think on top of that, when you're talking paramilitaries, you're actually often talking about entities which haven't even registered as a company entity. They are basically political forces or sort of non-governmental forces, but not commercial entities. It would be very unusual, I think, for most well-known multinational companies to be working with private military companies. Of course, obviously, you have some sort of fringe cases, particularly in the wilder parts of the extractives industry where that might be the case. But generally, the multinationals that we're familiar with are likely to be using private security companies. And I mean, there is another kind of complication here in that there is an ongoing UN process to try and put together a treaty to regulate this. And this has lumped them all together as PMSCs. And that's one reason why it's now been 6 or 7 years that this discussion has been going on and nothing has come of it yet, because there's sort of fundamental differences of definition. And generally within the space, you get private security companies very keen not to be bundled together with PMCs.
Right. Now, I mean, you mentioned the need for a treaty, and the talk for that clearly means there is a problem which the treaty would seek to address. So what are the risks of engaging these companies?
Well, arguably, there is a problem that needs a treaty, or there are problems with any sort of security that a company needs to employ, because they're always at the front line of what a company is doing. They are the people at the fence. They are the people who are there to protect against intrusion, against attack. They're the people who have to interact with disgruntled communities who may have a grievance against the company. So whether these are, companies who are stationed in shopping malls or office blocks or hospitals, or in more high-risk situations like mines and pipelines, there's going to be a risk unless those security guards are well trained, unless they understand what their use of force protocols are, unless they have been trained to understand what human rights are, how to be gender sensitive, and so on. So definitely there are going to be risks if you choose the wrong kind of private security company that hasn't met those sort of standards. What we tended to find, both in the work that we did on private security companies in Myanmar, and which ICOCA has done more generally, is that security guards are very poorly treated by their employers. And in particular, they're often working long shifts. They're often underpaid. They're not even often getting their legal obligations under minimum wages and so on. They may not have access to toilets, to water, and so on. So if you effectively, as an employer, abuse your security guards, there is going to be a high risk that they themselves become abusers. Or if not sort of physically abusing rights holders, they may become prone to corruption, for example, because they need that in order to survive because they're being underpaid. And this is a phenomenon which is very much driven by the market and the fact that many client companies, the multinationals, are just looking for the cheapest possible private security provider and not looking for a properly trained and well managed private security company.
So what sort of guidance exists for them?
So ICOCA has come up with a specific procurement guide, which you can find online. And one of the key points there is all around specifying in your tenders for your security guarding what kind of quality are you looking for, both in terms of performance, respect for human rights, but also in terms of decent wages, decent living conditions. And really a key point that any security manager in a multinational should be able to tell you off the top of their head is what it costs to pay that, at least that minimum decent amount, because often you'll see security companies just tendering at rock bottom prices, where it's quite clear that the guards themselves are going to be the victims of this contract. So good companies will both tender properly, but they'll also potentially be including some sort of certification, whether it be ICOCA membership and ICOCA certification, or the relevant ISO, which is 18788 and 28007 for maritime. And that will be part of the tender specification. So you can find that kind of guidance if you go online on the ICOCA website.
Yeah. Now, we know that there are rules of engagement for anyone with weaponry in the international humanitarian law. And we also know that the UN itself has codes of conduct and principles for the use of force by law enforcement officers. And we have the ICOCA code. Are there other yardsticks or codes that are useful?
So the Voluntary Principles on Security and Human Rights is an initiative, again, like ICOCA, a multi-stakeholder initiative that was introduced over 20 years ago, largely to address the risks around the extractives industry. And that is both setting human rights standards for the private sector, but it also deals with the risks around engagement with public sector security, whether it be police or military, and how multinationals should manage their relationships and potentially provide training and get into memorandum of understanding and so on with those state security forces, because they themselves can be a significant human rights risk for the company.
Yeah, I mean, that was in fact my next question, which was the guidance that companies can follow, not just the private sector. And BPs is a very good example, but it is restricted to extractive sector. But the issues that VPs have to deal with, community engagement, gender issues, dealing with privacy issues, dealing with security and use of force, go beyond that, which includes infrastructure. Government wants to build a highway or an airport, and they're going to have to displace people. So is there a need for something on those lines, which kind of expands it, or are there other codes available which can guide companies and not the security forces or private security companies to address the issue?
So the VPs themselves have been opening up their membership to beyond the extractives, and particularly I think where you have a company that in some way has some sort of use of land. So whether that's plantations for agriculture companies or infrastructure, whether it's hydropower dams, pipelines. So all of those companies are welcome to look at the VPs and potentially join. Likewise, those are going to be companies who will be using private security companies as well, who again, ICOCA is set up to service and support that relationship. But I think what's really important as well is beyond these very kind of international top-down multi-stakeholder initiatives, you need local discussions on the ground by companies and civil society groups, and in some cases, governments, around the local context and local risks. And it's that kind of thing which really helps a company to do more effective due diligence in this area.
Yeah, so the final bottom line that I would take away from this, if I were working for a company or a business, is that it's always advisable to go with a registered, accredited and credible private military or security company, as the case may be, and certainly not do what Chiquita did, which was to end up having relationship with a paramilitary force, which really does not really have any accountability built in, although, of course, the international humanitarian law applies to them. Yeah.
And I think on top of that, if a company is in a situation in a country or a region where they are going to have some sort of commercial relationship with a paramilitary group, they should really be asking themselves whether they should be there in the first place. And as the Chiquita case shows, they did have a choice.
Indeed, they did have a choice, and now they're dealing with the consequences of that choice. Yeah. Thank you, Vicky. And this was very useful what you said, including particularly mentioning specific codes and rules. So in the podcast notes that we publish along with this podcast, we will provide all the relevant links so that people who want to know more have a place to go to.
Thanks for that, Salil and Vicky. And thank you for listening to this episode of Voices, which is brought to you from the Institute for Human Rights in Business. Until next time, be sure to share and follow this podcast. That way you will never miss an episode. And if you'd like to find out more about the work that we do at IHRB, then head to ihrb.org.